Madam Chairman. Just want to bring the board up to date on a couple of items. I received an email from the in-house general counsel for Tomato Industries requesting that the grading permit be extended for another year. I sent that request on to Jamie and to Sean just to get the engineering eyeball on what's going on over there. Have there been any complaints? Are they in compliance with the reports? And I know Jamie and Sean both got back to me, and Jamie authored a review that said, yeah, there's some questions I need to have answered, but I don't see any problem in extending the grading permit for another year. So I wanted to make sure that Jamie had a chance to get his answers before he and Sean made the recommendation. But that's out there. They requested an extension, and I think from an engineering standpoint, Jamie and Sean really make a recommendation to the board. Secondly, Rick and Jamie both brought to my attention the issues concerning the Veterans Memorial Park project and the significant delay. And I think most importantly, Rick's concerned that if seeding isn't done immediately or within the next month or so, you run the risk of not being able to use those fields next year. Jamie basically got me involved yesterday, today, bringing me up to date on the contract, on the correspondence, the communications between his office and Plabcheck. And in looking at this, they are seriously in default of the agreement. The original bid that they proposed and accepted was a 90-day completion. And I think that 90 days was supposed to be up in December of last year. I know that Jamie is going to be getting me all of the emails and the correspondence where he said, you got to get out there, their response or lack of response, just to create a chronology. And then you as a board need to decide what route you want to take. I think the contract is very clear that you're in breach. You could terminate the contract, bid the remaining portion of that job out, but I'd like to have Jamie's input before you make that decision. But that's an open matter that needs to be addressed because it's festering. I just want to clarify Mr. Barna's position. He absolutely, unequivocally is entitled to serve on this board of supervisors. There's nothing in his past that's been made known to me. The litigation has absolutely nothing to do with him serving as a supervisor. Every supervisor still can protect their personal and their property rights even though they're serving. Any supervisor here can sue this township if something's going on. The only requirement is they have to abstain from deliberation, from executive sessions, and from voting on that issue. That's clear state ethics rulings. The two open matters, well, at least they're not open, two matters that are of record that have a docket number. One is the declaration of taking that we filed as part of the Gilmore Road project. And in Mr. Barna's defense, he was in the middle of litigation with the township on the sewage that was running onto his property and wasn't too happy about that. And I don't blame him at all. I mean, we litigated, but he was always a professional. You don't have to hate each other and be in court, okay? There are different issues that everybody needs to raise. And he just said, I don't want to sign anything. Well, in order for us to do that road project and not trespass, it is very common in road projects to file a declaration of taking so that our contractor can go on that area, and it's identified as a temporary easement in order to put the proposed pipe in, and that's what happened, and it's done. This was never sent to a board of review. Mr. Barna did not file any contest of the declaration of taking, and it's a moot, closed matter. The second item, and once again, it's out of his frustration for all the raw sewage that's flowing. He sued the township and said, that's your pipe, you're negligent, do something, okay? We filed preliminary objections to his complaint, and the objection was, we don't own that pipe, So therefore, we can't be negligent in terms of that pipe. And no one could prove who the owner was, even to this day. We don't know how it was installed, why it was installed, how or what got hooked into that so that sewage is flowing. And we raised a technical argument, a preliminary objection, saying you failed to state a cause of action because you didn't prove that we own the pipe and that we were negligent, and the judge ruled in our favor and dismissed his complaint with prejudice. That means you can't file again. So that matter is dead as well. That doesn't mean we're not responsible. It just means that the judge in that particular complaint said, I don't see anything that says you were negligent or that you permitted a real property defect to exist that damaged Mr. Barnes' property. It's the DEP that says you're responsible for the flow of raw sewage and you better do something about it. And that came about as a result of the Mingo Circle. Part of the consent order required that we do 537 studies, both of Mingo Circle and of Finnerville Arama. We got a grant, almost $50,000 to do that study. It's then been engineered, it's shovel ready and ready to go. Everyone knows we've been having some legal issues with Peters Creek, but even Peters Creek admits there's a sewage problem up there. Okay, so that, you know, they're arguing over, should it be lift station, should it be grinder pumps, and so that's in front of Judge Lucas. There's a full day hearing, it's been briefed, and we're waiting for a decision on how to proceed. But those are the two Varna matters that have a docket number in Washington County, and they're resolved. I want to report too that the township's insurance carrier agreed to our proposal to settle the gas matter for $2,836.42. If you recall, the township is paying $1,500. We propose that they pay the balance. They wholeheartedly agreed to do that. They're preparing a settlement release for our review. That matter is done, and it's going to be a full release with no further blowback to the township. If you recall, the decision was made not to turn that over for the insurance company to hire legal counsel, but that we would handle it as much as we could in hopes of effectuating a settlement. We have multiple claims out there that the insurance company's paying on. They've increased our deductible. At the very minimum, it's $5,000. It could be higher than that right now. So the very first $5,000 would have been on us, and there still could have been a rate increase. There still could have been more issues. That was a smart way to handle it. And I can tell you, I pulled all the time in my office that we put on guests from May of 2021. It totals 13.2 hours for a stated potential bill of $2,085.50. And I can also tell you that those happened in months where I, for almost 2 years, have either written off anywhere from 15 to 20 billable hours that I could bill, and threw on top of that a professional courtesy discount of a minimum of $1,000 each month. So if you factor in the discounts that occurred during these months, I doubt that you paid more than $1,300 in legal fees for us to handle what could have been a very slippery case. But that's been resolved.
Thank you for clarifying the amount.
A lot has been said about right to know. I think the very fact that our legal fees for right to know were so high, unusually high, shows you the great volume of right to know requests that this township was inundated with in 2021. We're talking hundreds. I haven't seen anything close in any of my other townships to this. Other solicitors I've talked to. Okay, so when you have these right to know requests, you can't ignore them. And at the time this all started, Bobby was a novice. She was just hired. She was feeling her way around the office just to learn township municipal secretary stuff.
That's 2020.
Please.
Which is important to understand why the board believed that an attorney was necessary. when these open records are filed, there are legal issues. It's not just a document, go look at a minute, copy the minute. There are legal issues such as privilege. Is the information privileged? Does it involve personnel records? Is it exempt from an open record discovery? And many times the response has to be based upon a reading and understanding of that statute, as well as the case law that's been handed down. Because there is an appeal process, and we've gone through it with the open records hearing officer, appeals up to the Commonwealth Court. That's how these cases can ultimately go, and that's another reason why I commend Bobby for keeping notebooks. It's extremely important that you have a record because it could be appealed. It could show up in a record. It could go to the Commonwealth Court. And we've had multiple requests that have gone to the open records hearing officer, and we've had hearings, okay? It's also important to note that many individuals used the right to know statute to obtain discovery in the multiple litigations we were involved in.
And we are still involved.
Yeah, and we saw the product of right to know requests show up in pleadings as exhibits, show up in motions, which was maybe the most important reason that an attorney looked at these right to know requests, because we were going to see them either in federal court or in state court, and we did many times over. So that's not unusual, and I commend Bobby for keeping it organized. We also had many times had duplicate requests, and we had to respond in that fashion too. Yeah, the bills were high, but Ms. Boring Evans takes shots at my bills, but she conveniently never goes to the last page to see how many hours I didn't bill, or how much money, real money, in legal fees that I discounted. So, you know, if you want to look at my bills, please look at the last page to see how I've treated this township for the last 2 years. I dare say that I have written off $50,000 worth of legal fees because I enjoy working with this board. I feel bad that you've encountered some of the issues. I have a personal stake because in the one federal lawsuit, I was sued personally for $6 million. So, yeah, it's more than just me being the solicitor. We've had to do battle. And as Heather says over and over again, it will come out. We will tell the story. You'll see everything. You'll see the stack of court decisions and motions and briefs and transcripts that we've had to develop, participate in, and defend. And with that, I'll turn it back over.
Okay, wonderful.
Just a comment on your right to know information. And I could be off a number or two, but in looking at, and I'm not saying that you didn't earn the money. I question how much we use you for right to knows. I believe from January through May of this year, it was somewhere around $1,800 for right to knows. I believe it was 17 right to knows. 9 of them, I'm saying till May, 9 of them were from board members and a board member's spouse. I'm sorry, 11 of them, I believe, was board members and a board member's spouse. And at least 7 of them were about Michelle Dupree from a board member's spouse. So, I mean, there is an easier way to do right to knows. If somebody wants if there's anybody in this room that wants my oath of office or my financial statement, try to alleviate the taxpayers' dollars and just ask me. I'll be more than happy to give it to anybody.
Okay, any other supervisor have a comment on the engineering, or excuse me, on the solicitor report? I have one thing I wanted to say. I thought you explained everything exquisitely. One thing I wanted to add on Mr. Varna's lawsuits, it's important that the public, and I repeat this a lot, and I know there's some people that don't like to hear it, but this board in 2016 walked into a gigantic mess here in this township. The primary one being 3 unsored areas wretched. That's a strong word because the DEP used that word in a letter to this township. It was embarrassing. I didn't know whether to cry or it was disgusting. The open raw sewage that Mr. Warren has been dealing with for, would you say 10 years? 10 plus years was handed to a modification of this board in 2016. So when we sat down, Attorney Sweat was new as well. When we first discovered Mr. Varna's lawsuit, we hit the ground running on 3 simultaneous sewage areas. One's buttoned up, wrapped up. One's in court, and Mingo, which is going to be a gigantic project, over $1.5 million, I think, total, $2 million. And it's going to be this township is going to have to manage a package plant. We're gonna have to hire staff to manage it. It's gonna create incredible relief for dozens and dozens of residents who are living in a very bad situation on Mingo. So when you look at engineering bills, that all costs, and that's only one section of the things that this board is doing. Where I'm not even talking about the bridges, the roads, the 2 major park developments. That all costs money, but our job is to improve the health and quality of life of our residents and the enjoyment. Everyone needs amenities. That's what you're paying tax dollars for. So that's what I wanted to say, and thank you for explaining that. So again, I don't want to cut anybody short. Is there anything else that anybody has to comment on regarding the